Production and distribution of City Club forums on IdeaStream Public Media are made possible by PNC and the United Black Fund of Greater Cleveland, Incorporated.
Hello, and welcome to the City Club of Cleveland, where we are devoted to creating conversations of consequence that help democracy thrive. It's Tuesday, October 22nd. I'm Karen Kasler, Statehouse Bureau Chief for Ohio Public Radio and Television, and the moderator for today's candidate forum, presented in partnership with the Ohio Debate Commission. The Ohio Supreme Court is the highest court in the state system, consisting of 6 associate justices and 1 chief justice. All the seats on the court are elected at large by the voters of Ohio. Starting in 2022, Ohio became one of only 7 states that elects state Supreme Court justices based on partisan elections. This November 5th, 6 candidates will be running for 3 open seats. Invitations were extended to all 6 candidates, and with early voting now underway, we are fortunate to be joined this afternoon by 3 of those candidates. Starting down at the end, Michael Donnelly, Justice of the Supreme Court of Ohio. Melody Stewart, Justice of the Supreme Court of Ohio. Sure. And Lisa Forbes, Judge of the 8th District Court of Appeals for the state of Ohio. So before we begin, let me first explain the format of today's candidate forum. We will first hear 5-minute opening remarks from each of the candidates, starting with Justice Donnelly and going down the line. After their remarks, we'll move to a panel conversation that I will moderate. And keeping with City Club tradition, an audience Q&A will follow the panel discussion. For our live streaming audience, if you have a question for our candidates, you can text it to 330-541-5794, and City Club staff will try to work it into the second half of the program. Members and friends of the City Club of Cleveland, please join me in welcoming Justices Donnelly and Stewart and Judge Forbes. So we have the 5-minute opening remarks there, so Justice Donnelly, go right ahead.
Thank you very much. Good afternoon, everyone. It is certainly an honor to be here at this historic institution. Once again, this is the second time, so I consider it a great honor. My name is Michael Donnelly, and since 2019, it's been my absolute privilege to serve as your Associate Justice on the Ohio Supreme Court. But to be honest, it's a position I never aspired to. I started my career as a county prosecutor for the late, great Stephanie Tubbs Jones. Then I went into civil litigation, yeah, that's absolutely, and practiced for a total of 12 years. And then in 2004, I ran for a seat on Ohio's largest trial court, the Cuyahoga County Common Pleas Court, where I served for 14 years. And to be honest, I absolutely loved that job. I thought I would retire a trial court judge. I loved being part of the process of bringing resolution to conflict in people's lives. And that's what the courts do. We resolve conflicts and we protect people's rights. 9 of those years were the most rewarding for me because I served as a mental health court judge. 25% of my felony criminal docket was made up of people who suffer from schizophrenia, schizoaffective disorder, and developmentally disabled individuals who found themselves in the criminal justice system. And I'm very proud of the fact that we were able to keep the great majority of them out of the prison system, where they often go in, become abused, and come out worse than before, mistreated. And we were able to keep the community safe. So it taught me there was a better way of doing things. In 2018, 2 seats became open on the Ohio Supreme Court. And I thought to myself, that would be a position where if I could speak with greater influence to advocate for much needed criminal justice reform and civil justice reform, to improve our system for the next generation, that I would value that position. So I took a chance with my junior colleague and friend, Justice Stewart. We traveled the state of Ohio and talked about things that I'm very passionate about: transparency. As a judge, I found that I did everything on the record down at the Common Pleas Court, because early on in my career as a judge, I came to the conclusion that no one should ever do anything or say anything in the back room that you wouldn't repeat verbatim. So I changed the policy in which I engaged with litigants, and I did everything on the record. And that way, everyone was held accountable for what they represented, including myself. So I ran on this platform of transparency, and it's been a dream come true at the Ohio Supreme Court. I've been able to advocate for those very policies that I'm talking about. And one of the ones I'm most passionate about is advocating for data-driven criminal sentencing reform. We have 50,000 people in the prison system. I think we're number 5 in the United States. And every practitioner knows, and they'll tell you this is the truth, that with the lack of data and our antiquated sentencing laws, they are programmed to produce both racial disparity and just general disparity every single day. And my contention has always been that public confidence is threatened when people believe that their sentencing outcome is more tied to whichever sentencing judge that you're randomly assigned to rather than the rule of law, which requires consistency, fairness, and proportionality. And any practitioner who practices in the Ohio system can tell you that you can have a sentencing hearing in one judge's courtroom, carry that out with the same lawyers, the same facts, and have an outcome of probation. You can take those same lawyers, same facts, walk 15 feet across the hall, do it again, and wind up with an outcome of 20, 30, or even more years in prison. It's all over the place, and I've written a paper on it called "The Guardrails Are Off." And we need to fix this program by moving towards a centralized sentencing database. I've been the most vocal advocate for the creation of this much needed, because our trial court judges are directed under the law to treat similarly situated defendants with similar sentences regardless of such irrelevant factors like the color of their skin or their socioeconomic place in society. But they are powerless to do this with these lack of guardrails and lack of data that keeps them consistent with themselves and consistent with the other judges in the courthouse and throughout the state. So that's what I want to continue. I'm also a big advocate for improving the post-conviction system in Ohio. Oh, am I running time? Okay. Okay, we'll talk about what else, but it's maximum transparency, maximum fairness, and maximum efficiency. That's what I pledge if I'm reelected. Thanks very much.
Justice Stewart.
Thank you all for being here. So I'm Justice Melody Stewart. I'm a native of this great city. I was born and raised here all my life. I grew up in the Huff neighborhood of Cleveland back in the 60s during the Huff riots. I remember vividly, although I was just a small tyke, I remember vividly the smell of burning buildings. I remember looking over the windowsill and having my mother say, "Get away from the windows, honey, get away from the windows." I remember armored cars going down our street, and I remember there being some talk about a curfew, although I didn't know what that was at my age. So I remember that time being interesting, and I vaguely remember thinking this wasn't a good thing, but somehow, some way, I will know what this means at some point in my life. I was raised in the Huff neighborhood by a single mother who had me later in life. My mother was almost 40 when I was born, and she was born and raised in the segregated South, where schools for Black or Negro children only went up to the 8th grade. And she was one of 11 children, 9 girls, 2 boys. When the girls finished, they either stayed in their small town in Virginia and worked as a domestic, or moved up north to live with a sibling, an older sister, for better opportunities. My mother did the latter, moved to Washington, D.C. first, and made her way here to Cleveland, where she worked for and retired from the U.S. Postal Service. My mother died in 2000 when I first ran for the Court of Appeals. She died the morning after my first fundraiser. So she never got to vote for me. I remember us sending her ballot back from the nursing home, and so she never got to see me be a judge. But everything I am, standing here before you, is due to her. So when I was going through her things in 2000, I found out that she went back and got her GED when she was in her 60s, 1 year before I finished college. But my mother taught me the love of the arts and the love of education. She acted here at Caramoo Theater in the 40s and 50s, before I was born. She taught me how to play Scrabble and Password, and I didn't beat her in Scrabble until I got to college. She instilled in me the love of the arts and worked overtime at the post office so that I could simultaneously study music at the Cleveland Music School settlement while I was in school. So I majored in music at the Conservatory of Music at the University of Cincinnati, because with the name Melody, what else would I study in college, right? So I'm a classically trained pianist, and I took that music degree, promptly got a job in the healthcare industry for my first year out, and was intellectually bored. Applied to law school, spent 3 years in law school saying, do I really want to be a lawyer? Do I really want to go to law school? I did that. I started civil defense litigation for the city of Cleveland when George Voinovich was mayor. I then went into law academia. I was a law professor here at Cleveland State University, at the University of Toledo's law school, an assistant dean at CSU, and director of student services at Case Western. I've had the privilege of working for 3 of our 9 law schools in Ohio. Then I ran for the Court of Appeals and was finally successful in 2006, where I served for 12 years. The 12 years on the Court of Appeals, plus my finishing up my 6th year here on the Supreme Court, makes me the most experienced appellate jurist currently sitting on the Ohio Supreme Court. Thank you. And while I was at the Court of Appeals, I went back to school and I got a PhD from Case Western Reserve, the Mandel School, because that degree helps me to ask the right questions. And it helps me to think about possible unintended consequences of decisions that we make as jurists. And so I'm running for re-election under the same things that my senior colleague, and by the way, senior by 23 hours and 59 minutes, I just want to, but he constantly reminds me of it, but running for maximum transparency in our court, to make more efficient and more effective courts. We did some of that when we got there. We extended the filing deadline from 4:59 to 11:59. We got rid of some of the paper that got circulated so much in our court and went to electronic distribution of things. And so I will stop there because I don't want to get the high sign like Mike Donnelly got, and answer any questions that you have, but hopefully will return me to the court in 2 weeks. Thank you.
Judge Forbes.
Well, good afternoon, and thank you all so much for coming out. You can hear my voice is a little bit funny. I was indeed at the Guardians game on Friday, and I'm not quite over it yet in every way. But so I'm Lisa Forbes. I'm a judge on the 8th District Court of Appeals right here in Cuyahoga County, and I'm running for this Supreme Court to fill the unexpired term, fill the open seat. And I'm running because I want to do my part to make sure that the Supreme Court is a firewall that protects our democracy, the rule of law, and your rights. Yes. And I want to make sure that the Supreme Court is fair, is balanced, and is independent. Those traits, those things are lofty goals, but they're also what the Supreme Court should be and what the Supreme Court should do. And so I stepped up to the plate because I'm concerned about some rulings. I'm concerned about the way in which the court has the power to define words and to interpret laws that may be more result-oriented than true to the law or to the intent behind the law. So that's why I'm running. And I mean, one example I can give you now, the famous boneless chicken wing case, where the word boneless was defined as a matter of law to mean it's a cooking style, and was taken to mean that you should expect bones if something is labeled as boneless. And I think that's concerning going forward. I will pledge to you that I will bring my expertise in the law, my commitment to community, and my work ethic to bear, and that if I am elected to the Supreme Court, and that if I need to define a word, I promise you that I will use a dictionary. So I'll just give you the quick informational background that, as I said, my expertise in the law comes from the 27 years that I practiced law in courts all over the state of Ohio, trial courts and courts of appeals. I was a partner in a national law firm for the majority of that time. I left my partnership when I became a judge on the Court of Appeals. I did that because I really felt called to public service. As I was looking to the last chapter of my career, I wanted to give back to the law and to the community in a more meaningful, comprehensive way. So that is what brought me to the bench, and I'm happy to say the people of Cuyahoga County did put me on the Court of Appeals, where I very much love my job. I get to go in every day, confronted with the words above the bench at the 8th District Court of Appeals. And those words are that ours is a government of law and not of men or women. But that is an important founding concept in our country, and one that I try to bring to bear every day. My commitment to community comes from many, many years as a volunteer, including my years of service on the board at the centers. I just finished a term as chair of the board there. And then, and that is an organization that helps provide high-quality health care, both physical and mental health care, job training services, Head Start, and residential services for adolescents who don't have parents to take care of them. And then my work ethic I get from my family. I'm the granddaughter of immigrants, and I am my grandfathers were both coal miners in Western Pennsylvania, and I am a first-generation college graduate. College came possible to me through things like work study, student loans, and waiting on a whole lot of tables. So I tell you that because I appreciate that as a candidate for the Supreme Court now, as a judge on the 8th District, I should say, and candidate for the Supreme Court, I appreciate that I am a living example of the opportunity that my grandparents came to America for, and I want to make sure that that is available for generations to come. So that's a little bit about me, what I'm concerned about, and what I hope to bring to the bench. And I look forward to the rest of our discussion today.
I'm glad you mentioned the voice. I was at 2 games, so that's why I sound like this. Didn't help. Well, let's just launch right into the politics of this, because there are politics of this now, because as I mentioned in the intro, you are all running under party designations. You're listed at the very top of the ballot right after the presidential candidates. And you've long been endorsed by political parties in terms of candidates for the judiciary. You all said to me, because I've had the privilege of talking to all 6 of the candidates, that you're running as independent candidates, not as part of a team. But it's likely that voters are going to view you as part of a team because you do have those party designations. So with all that in mind, should this race be nonpartisan, or does, as the Republicans have told me, the party designation give voters important information? And I'll just start with you, Justice Donnelly.
Sure. Yes, I've been on record since 2011 saying we should have an absolutely, completely nonpartisan judiciary. If we're going to have an elected judiciary, it should be nonpartisan. I'd like to see us move towards some type of retention system where we don't have to run each other or against each other and raise money. But if you look at my political handouts, you won't see the word Republican or Democrat on here. I stress my independence as a jurist, and I think that's the way it should be. This party label was thrown on me by a legislature, and everybody knows why they did it. It was opposed by the Ohio State Bar Association. It was opposed by the Ohio Judicial Conference, made up of jurists who are supported by both political parties. And they said, why are you doing this? And former Justice Pfeiffer, who heads the Ohio Judicial Conference, went down to when this was being debated and told them, we all know why you're doing this. You're doing it to keep Democratic-supported justices off. And you know, when I take the oath, I don't take an oath to any political party. My oath is to follow the law of the state of Ohio and the United States of America.
Justice Stewart?
Yes, it does give information, but I don't think it gives important information. There's a reason why we don't have any jurists in our state who are unaffiliated either way with the other party or truly independent, because the parties rule and control everything. But the judiciary, the judicial branch of government, is really unlike the executive branch and the legislative branch in that they are always doing things that are political. In the legislature, there's horse trading. You know, you vote for my bill, you know, I'll vote for your bill. In the executive branch, they can come out on positions. They can put words on ballot petitions that don't represent what the petition is, ballot language. They can do all sorts of things political and suffer no consequences from it. We can't in the judiciary. We're guided by the Code of Professional Conduct and the Code of Ethical Conduct, of Judicial Conduct. And we don't barter. We don't go into conference and say, well, you vote for the case, you side with me, I'll side with you on that one. Our oath is to uphold the law and the Constitution and laws of the United States. And so what putting party affiliation on the ballot has done, because we were, of course, supported by our parties. In the media, there's no way you write about us without writing about our party labels. So it's not like we were keeping it a secret. But what they've used it as is a weapon to politicize our courts more. This is the first time all three of us have run with a party affiliation on the ballot. And so it has the voters focus on things that are not really salient to whether you're going to have a good public servant in that office. And there's no doubt that my opponent, who is a sitting colleague, there's no question that he would be running against me if he didn't have party affiliation on the ballot, because he's so unqualified for the job.
Judge Forbes?
Yeah, I think that I find it very disturbing, because I think, as Justice Stewart was just saying, I think it gives the wrong impression that we're political actors. When we are ruling on a case, it should be wholly dependent on the law and the facts of that case, and not any broader, question. There's no overarching dedication, commitment to anything but the law and the facts. The biggest concern I have about it is that it creates the impression that perhaps affiliation with a party is going to impact an outcome of a case. And that degrades the public confidence in the courts as a whole. And that's very disturbing. Right now, confidence in the judiciary to actually dispense justice fairly and even-handedly is at an all-time low, and according to public opinion polls. And that's not good in a democratic society that is dependent on this social compact that we all have with one another, that the law is going to be, as I said at the outset, we are a government of laws, not of men. This is about our agreement for how our democratic system of governance is going to work. And undermining it in this way, I fear, has much broader implications.
Some of the decisions that come out of the Ohio Supreme Court do end up being political. For instance, when I talked to all three of you, you all cited the boneless chicken case, boneless chicken wings case, as an example of a ruling that maybe you didn't care for. But the Republican candidates, when I talked to them, they all cited the DuBose decision as a reason why they are running. That ruling limiting excessive bail and saying public safety should not be a consideration in setting cash bail, it sparked a constitutional amendment that basically overturned what you did. The Republicans I spoke to had some harsh words for that decision. Justice Deters called the ruling idiotic. Judge Hawkins said it was outrageous and a step too far. Judge Shanahan said she was concerned that a jurist is putting our public at risk of violent offenses being committed. So I'm going to start with you, Justice Stewart. What can you tell people about that decision, because you were on the court when it was rendered?
The first thing I tell people is that decision was the absolute dog whistle for the 2022 election for the Supreme Court. That was a case that totally misconstrued the law, that both, I'm not sure about Judge Shanahan, but clearly Joe Deters, as probably a political favor to the DeWines, made that case more than what it is. So that case dealt with a defendant who got a cash bail at some large amount, probably, I don't know, 1.5 million or something. I don't remember the exact number. And then the prosecutors brought family members in of the victim of that crime and said, well, no, they're fearful of this guy. And so the judge elevated the amount to get out by some public safety. Let me first let you explain what bond and bail is. It is to allow release and ensure return for your hearings of the court. I'll say that again. Bail and bond amount, cash amount, is to allow release and then return to your hearings. So if you set an amount that is unattainable, you're not allowing release. And if someone is dangerous and poses a threat to public safety, how about we just keep them pretrial with no bond? So what amount will make you safe? If defendant A is charged with attempted murder and the bond is $100,000, and defendant A is wealthy, and defendant B is charged with attempted murder and the bond is $100,000 and he makes $25,000 a year, this guy can get out on the $100,000. This one cannot get out, and yet they're charged with the same crime. So are we safer then? Because that $100,000, he got out. What amount would make someone safe? The analysis of whether someone poses a threat to public safety and whether they should be held is at the time of setting bond or not. But once a judge decides, yes, you're bailable by cash bail, then that amount is to allow release. If you set an amount, when you ask the public, well, how much is enough? Well, to make you feel safe. And if the answer is enough not to let them out, then that's not bail. And just for follow-up, for the final thing, the fact that they use that as a dog whistle, put it on the ballot, use the most simple language when particular members of our elected officials want something, it's in simple ballot language. Should judges be allowed to consider public safety when setting bail amount? As contrast to the language that they put in for some of the other things that they don't want. So if you were in a coma, you'd vote yes for that. I explained to people that that should have been that that's not what it meant. And if we were wrong in the decision, then why did there have to be a constitutional amendment?
I want to ask both of you to weigh in. I'll ask you, Justice Donnelly, since you were on the court and wrote a concurring opinion.
Sure, I wrote the concurring opinion. It's interesting that they would have such harsh words on a one-on-one interview with you, but where are they here to talk about that right now? Because I would like to talk to my opponent about that, because I wrote the concurring opinion that said, if someone's a threat to public safety, you should have a hearing and hold them with no bond. Don't set it at some astronomical amount that you think they can't make. And she doesn't have a good response to that, and that's why she's not here, and she doesn't want to talk. But if you want to talk about public safety, let's talk about an effort that I led in 2016 to eliminate what I call factually baseless pleas. These usually happen in Cuyahoga County Common Pleas Court, or Common Pleas Court throughout the state of Ohio, where someone is charged with a serious sex crime like rape. And if you have the right lawyer and the judge and the prosecutor is willing to go along with it, you go in the back room and you allow them to plead to a crime that has nothing to do with rape, an outcome that a jury could never produce. A lot of times they plead these cases to a crime known as aggravated assault. In fact, I have data from Hamilton County that has 2 cases on my opponent's docket that I would like to ask her about, but she never shows up and I never get to ask her about those cases.
Judge Forbes, again, you weren't on the court when this ruling came out, but what are your thoughts?
My thoughts on it are, if you want it, it's a great irony, let me say. It's a great irony that the people who recognize that dangerous criminals should under no circumstances be given an opportunity to be released pre-trial, which is what Justice Stewart and Justice Donnelly just said, are the ones being tagged as soft on crime, whereas the alternate position is all you have to do is pay a sum of money, and then you can get out. That is soft on crime. Hard on crime and protective of the community is making the assessment that says under no circumstances may you be released pre-trial. Just, it's ironic the way it's been recast.
We're going to go to audience questions here in just a moment, so be thinking of questions, and if you're watching on the live stream, please feel free to share your questions. But I want to ask you before we do that, we often hear the phrase legislating from the bench. So I want to ask all 3 of you, what does that mean to you? And I'll start with you, Judge Forbes.
I think legislating from the bench is when you try to achieve an outcome that doesn't naturally flow from the law as it exists. So I am opposed to legislating from the bench. I don't believe that that is the job of a jurist. And as a Court of Appeals judge, and when I am on the Supreme Court, I will have a tool available to me. When I disagree with the way a law is written, I will have the opportunity to write a dissent, for example. Or perhaps I agree with an outcome but disagree with the law for some reason. I can write a concurring opinion in which I point out that this needs to be changed because there's a problem that flows from, or that I see flowing from the law. But as a judge, my job is to apply the law. It is not to create new laws. So legislating from the bench is creating new laws to achieve a particular outcome. I won't do that.
Justice Stewart.
Sure. Our jobs as jurists is to say what the law is, not what it should be. And as Judge Forbes says, the beauty about being an appellate court judge or Supreme Court justice is we do get to write about it. There are times we have to make decisions and vote on a judgment based on what the law says, and we hold our nose doing it. And that's where we get to write about this is an injustice, or maybe the legislature did not intend this, but this is the outcome results. So, you know, I'll say my opponent, probably ours, but I'll just stay focused on mine. We'll use the catchphrases, the typical legislate from a bench, liberal activist judges, you know, all those sort of words that are dog whistles. And I implore him to just show up anywhere with me, a street corner, a candidates forum, an editorial board, anywhere, and just discuss the substance of our candidacies. And he won't do that because it's hiding behind the catchphrases of liberal activist judges, and it's hiding behind party affiliation on the ballot so that there does not have to be any offer to the voters of why he, someone who the Ohio voters have never elected to a judicial seat ever, thinks he should be elected to one now, and also be elected to one and have me removed from the bench. Just one reason why the Supreme Court is better served with him on it than my being on it. And he won't show up with this to just say, because you're a liberal activist judge. Well, okay. I'm also between Aquarius and Pisces, too. I don't know if that matters.
Justice Donnelly.
Sure. When I was fortunate to win a seat in 2019, I sat down with my clerks, and as judges, we all have our biases, and I told them, look, the law is the law. I never want to be accused of engaging in, as Judge Forbes said, result-oriented analysis. What's the result that I want on this, and how do I find a pathway, no matter how ridiculous? So I wrote the dissent in the boneless chicken case, and that got lots of laughs from late-night comedians. But in actuality, it's a very serious case because the gentleman involved in that case was severely injured, life-altering injuries, that he was seeking compensation for his medical bills that he incurred. And what the law says is that if reasonable people could differ as to whether to expect a bone in a boneless chicken wing, then that's an issue of fact that should be decided by a jury. Your right to a trial by jury is in the Ohio Constitution and the federal Constitution. So that should have gone to a jury. I never said that someone should be held negligent. That was to be determined there. But what have they done in terms of legislating from the bench? They have immunized an entire industry and put people at risk. Children who are fed chicken tenders. You now must expect that there might be a bone in there that could severely injure them. And that's what they did. The legislature could have done that. Shouldn't be done by a majority of the court.
Let's include some audience questions now. For our live stream audience or those just joining, I'm Karen Kasler, Statehouse Bureau Chief for Ohio Public Radio and Television. We are here with 3 of the 6 candidates running for the 3 open seats on the Ohio Supreme Court this November. We have, going in order, Michael Donnelly, Justice of the Supreme Court of Ohio, Melody Stewart, Justice of the Supreme Court of Ohio, and Lisa Forbes, Judge of the 8th District Court of Appeals with the state of Ohio. We welcome questions from everybody. City Club members, guests, those joining our live stream at cityclub.org. If you'd like to text a question for the candidates, please text it to 330-541-5794, and City Club staff will try to work it into the program. So let's go ahead with the first question.
Good afternoon. I'm so glad that City Club was able to have you here. I've been doing some presentations on Project 2025, and it just has a whole lot of stuff that is just outrageous. One of the things it calls for is warrantless searches, to be able to go into homes with no search warrant. Reverend McMickle was giving a presentation, said it was a violation of the First and Fourth Amendment. It calls for police immunity, getting rid of consent decrees, just a whole lot of stuff that would hurt a lot of people. So my question is, and I'm not asking you to be, fortune tellers or anything, but just in the position that you are, if that were to happen, do you think people in Ohio would be able to eventually end up at the Ohio Supreme Court trying to undo those warrantless searches and the phone taps with no permission from a jury or a judge or anything? Do you think that the Ohio Supreme Court would have any kind of power in being able to undo that kind of thing?
Who wants to start?
So, if these type of ideas are implemented, I'm envisioning another country than the one that I've grown up in. And when we sing the national anthem, we talk about, does that flag still wave over the land of the free? It's our freedoms that are enshrined in the Bill of Rights, the right to be protected against unreasonable searches and seizures. You need independent courts to give those words meaning and to enforce those rights. That's what courts are there to do, to resolve disputes and protect those rights. There's a lot of rights that people are concerned about. Workers' rights, reproductive rights were just enshrined into the Ohio Constitution. And listen to the rhetoric of our opponents out there. When they're asked about this, they don't say what we say. We'll protect your rights. They say, we will apply the law as written, brought to you by the same gang that bought you boneless chicken wings packed with bones. Beware.
Justice Stewart, Judge Forbes.
Anything that challenges a constitutional right could make its way to the courts without question. We obviously can't say how it would rule or what we rule. We don't even know what the issue might be. But keeping in mind, a brief civics lesson, at the trial court where Mike Donnelly served, you have a right to appeal a decision from a trial court. The jury got it wrong, the judge was wrong in letting evidence in or keeping evidence out. You think the judge made a mistake, you have a right to appeal to the Court of Appeals, where I served for 12 years and where Judge Forbes currently serves. You have an absolute right to get there. You don't have a right to get to the Ohio Supreme Court. We have narrow confines that take our court cases in. Dealing with constitutional issues is one of them. Cases dealing with felony matters and cases that are of general interest or great public importance. So we get to pick and choose the cases that come in. So if you don't have a court, in my opinion, a court that is diverse, intellectually diverse, geographically diverse, educationally diverse, background diverse, things that some justices might think is of great importance, a great public interest, some others might not think that are. And so that's part of why I think the makeup of the court needs to be as diverse as possible, and certainly not all one party or another. So we would get to, that would seem to be an issue that would readily be accepted by all 7 members of the court, something dealing with the constitutionality of rights, but that's not necessarily so.
Judge Forbes?
Yeah, and I'm not as familiar with Project 2025's particulars as you are, so I not really. I think that something like that you were just describing would require a constitutional amendment to the United States Constitution to get rid of.
Which won't happen.
Pardon?
Which won't happen.
Right, I was going to say, which is very, very difficult. Remember, the United States Constitution has 27 amendments. The Ohio Constitution has 173, with 174 on the ballot this year, if it passes. So I think that it's concerning what the topics you just raised, because they are fundamental rights, or have for the last 237 years been considered to be fundamental rights, and that they would be in question. But I would have to see how it came forward to see exactly what was going on.
Let's have another question.
Thank you. It's good to see you, our esteemed jurists. So Article 1, which I believe is our Bill of Rights, the Ohio Constitution, has 22 Bills of Rights, and in contrast to the Federal Bill of Rights, which only has 10. The 22nd is the newest, and it was passed last year by the citizens of Ohio by overwhelming majority, in response to a regime under which 10-year-old girls were chased out of the state to seek medical care, and women were threatened with danger if they dared to miscarry during a miscarriage. So now we live in a state where reproductive freedoms are enshrined in the Constitution by the citizens, not by the court. So I'm not asking your judgment on that amendment, but the citizens of Ohio passed an amendment into the Constitution. And when I was a kid, in most of my adult life, I thought a court would abide by, in fact, one of its jobs, the Supreme Court's jobs, was to enforce the Constitution.
Well, we need to get to the question.
Yes. So the question, what I'm hearing is from your opponents, is that there's intimations that they would see the Supreme Court as a tool with which to nullify that amendment, to overthrow the will of the people and the amendment of the Constitution. We hear this from Republican legislators. And so my question is, my question is, what is your stand on protecting the Constitution as a justice of the Ohio Supreme Court?
Who wants to start?
Yeah, I'll start. As President Andrew Jackson said years ago, those words on that in the Constitution are a mere bubble and mean nothing unless they're enforced by a independent judiciary, and that's what we are sworn to protect, regardless of our position on this. You know, it shows you the chaos that has been thrown into this country by the Dobbs decision. You had Justice Alito say this is a matter for the states, and women are not without electoral power. And what did the Ohio legislature do in response to that? First of all, they tried to raise they changed the rules in changing the amendment by raising it to 60%. They held, in what my opinion was an illegal August election in order to do that, and the voters let them know how they feel about that. They enshrined those rights back into the Constitution. But the fact is, those rights cannot be, those rights are still at issue if you don't have an independent judiciary willing to protect those rights. And that's what we will do. And interestingly, our opponents have always worn this right to life endorsement on their sleeve. In 2022, they were endorsed pre-primary without primary opponents in that cycle. They didn't endorse until September this year. Why? Why are they not highlighting that right to life endorsement that they've been so proud to wear on their sleeve? It's interesting.
Yeah, all three Republicans are endorsed by Ohio Right to Life. You folks are all endorsed by Planned Parenthood of Ohio. Judge Forbes, Justice Stewart.
I'll just say that, you know, one of the things that that Justice Donnelly was just referencing is the idea that the Article 1, Section 22 of the Constitution, it is going to be coming through the courts in all likelihood. Now, we don't know for sure whether any of those questions are going to come to the Supreme Court, but we do know that the courts are involved in this, and that's because after 57% of Ohio voters voted to enshrine reproductive freedom in the Constitution, superseding then any statutes, our legislature did not repeal any of the existing laws on the books. The courts could be taken out of this discussion if the laws that are presently on the books were repealed by the legislature, but the legislature isn't doing that, preferring the courts to do that work, to say which laws are unconstitutional in light of the Reproductive Freedom Amendment passed. And so I think that does beg a question. Why? Why are we doing that? I guess I don't know really, but as I said at the outset, I understand how the rules of interpretation are supposed to be applied. I do it every day as a judge on the Court of Appeals, and that is where the law is and the words of a provision are clear and unambiguous, they are to be applied as written. If there's an ambiguity, then the rules of interpretation get brought to bear, and that includes if a word needs to be defined, that we look to things like standard tools like dictionaries and precedent, and I will do that to give voice to the intent behind the provision.
Justice Stewart?
I don't have much to add to those, so I can pass on that one.
Another question.
Hi, thank you all for being here. My question has to do with the party distinction on the ballot. I had the privilege of voting yesterday, and I noticed that party distinction is only for the Supreme Court candidates, not for trial court judges that we also voted for. So my question is twofold. One being, what is the powers that be that allowed for party distinction in general? Like, what is their argument in favor of that? Obviously, Ohio is a predominantly Republican state, and it's easier for them to win, but that's not necessarily something they should say out loud. So I'm curious, one, what their argument is, and two, why that distinction doesn't apply to all levels of trial, appellate, and Supreme Court, even though they're elected officials.
It does apply to appellate court justices as well as Supreme, but you're right, it does not apply at the trial level. Let me ask Judge Forbes, since you are on the appellate court,
So what is the rationale behind that?
Party doesn't make
You know, it's mystifying. The explanation at the time was that something about people weren't really interested in knowing party affiliation behind their trial court judges. Either it's meaningful information or it's not. I don't understand this distinction that's been made. I will say from a practical standpoint, traditionally, the judges who run for Supreme Court are judges who have served on appellate benches, not always. But if there's, perhaps that had to do with it, trying to get rid of some qualified appellate jurists, I don't know. I can tell you that the first year that law was in effect, which was in 22, numerous judges lost, appellate court judges lost, incumbent appellate court judges lost their seats in communities all over the state. Republicans lost in cities, and Democrats lost in more rural areas. And that's a pity for the state of Ohio, right? We lost good, experienced jurists. Why? I don't get it.
And as Judge Forbes said, their purported reason was that to prevent voter fall-off, but it's purely about power and outcomes that they desire, and that's what they're doing. And there's evidence that the press can go to where not all Republicans, before they put this party label, were thrilled with this. In fact, there's my colleague, the Chief Justice Kennedy. She always enjoyed getting a lot of Democratic votes in the cities because her name was Kennedy. And if you go into the congressional record, or the legislative record when this was being considered, you'll see Representative Bill Seitz go to the people and say, would you consider a motion to have the Chief Justice race, which she was running in against Justice Bruner, would you consider a motion to have that go be nonpartisan and have the other judges partisan? And they're like, we could do that, but how do we stick with our plan that this is about transparency? And it didn't. But there's a plan afoot to gerrymander the appellate districts. The 12 of they tried to put this into place. All the judges know about it, and they want to break up the first district, which they consider producing too many liberal outcomes. And this is the facts. Everybody knows it. They just don't want to talk about it out loud.
And my position on that too, because my colleague Justice Pat DeWine wrote an article that said it's a good start to put party affiliation on the ballot, and I couldn't hold back, so I wrote an article in response to that saying, you know, how is it that all the judges in the state of Ohio take the same oath? We all have 6-year terms. The Supreme Court and the appellate court, we don't see people in our courts. You know, externs and lawyers excluded, but you know, we don't see parties. Trial court judges have juries. Trial court judges see the parties, defendants sitting there, parties in a case. Trial court judges have family members in the court. Those are the people who every day terminate your parental rights, sentence people to prison, rule on your personal injury cases. Those are the people who see people every day. And to say that people don't want to know the party affiliation of the hundreds of trial court judges across the state. There are only 7 of us on the Supreme Court. And there is, oh, they're trying to get you to sit down too? Okay, well, I'll answer as you sit down. To say that there's there's 7 of us on the Supreme Court and there's 69 appellate court judges. So people only want to know who those 76 judges are, as opposed to the hundreds of trial court judges across the state. It was done because the state of Ohio has voted, and someone said we're predominantly Republican. We are not. Ohio is primarily unaffiliated voters. The registered voters in Ohio are primarily unaffiliated. This was done because Ohio has gone Republican in the last 2 presidential elections. I guarantee you, with the supermajority in this legislature, if the state of Ohio had been voting Democrat in the 2 years that Barack Obama was elected president, there was no talk to changing party affiliation, putting party affiliation on the ballot. But now that there's a momentum, a swing toward voting Republican, they did that. It was also convenient that it started in 2022. when Governor DeWine was running for re-election, and his son, Pat DeWine, was running for re-election. So now you put party affiliation on the ballot, and you move the races up so that they're right after the executive, all done by design. Now end with saying there would be no way that my opponent would be giving up a seat of incumbency to leave his seat and run for mine. If I were a Republican, would he be running against me? Absolutely not. If I was a Republican and Mike Donnelly was only Democrat, would he just switch over to Mike Donnelly? If we were both Republicans, would he run for his own seat? And so why would you give up your place of incumbency to retain your seat to then go against a more experienced jurist if you didn't feel that party affiliation was the end-all, be-all for your race? And that's why they put it on strictly political reasons.
And I'll just say, if anybody in this audience agrees that we shouldn't have party affiliation on the ballot, I'll encourage you to vote for me, because I'll be the one that will flip the court, and then we can, perhaps the legislature will reconsider the benefits and value of party affiliation on the ballot.
And it should be clarified that, yes, Justice Donnelly and Justice Stewart are running for full 6-year terms, and Judge Forbes is running for the rest of what was Justice Sharon Kennedy's term before she became Chief Justice, and that's the seat that Joe Deters was appointed to.
Correct.
So
You got it.
just to clarify all of that. One more question I think we have time for.
So I actually think, Judge Forbes, you might have answered this a little bit already, but in many cases, they come down to interpretation of certain terms that may be vague or ambiguous, like you were mentioning. You know, what comes to mind, the issue 1 ballot language. There's been plenty of cases at the U.S. Supreme Court as well where this is an issue. And so what sources do you use to resolve that ambiguity or that vagueness? Judge Forbes, you mentioned a couple of them, but I was just curious if you could all elaborate on how you resolve those issues.
I'll defer to the two who have recently ruled on that very question.
So I wrote the dissent on the issue 1 ballot language, and you know, that language is supposed to be neutral and let the parties out there who think it's a good idea or a bad idea get out and campaign for yes or no, but it's not supposed to be, the law dictates that it's supposed to be advocate one side or the other. And when you say that this effort to ban gerrymandering actually requires it, it's confusing people. I received a call from someone in Washington County just the other day, and described an elderly gentleman coming in, and he's reading the ballot language, and he says, "Hun, why do we have a yes sign in our front yard?" And that's wrong. You know, we should be following the law and having neutral language, but we don't have a majority, so we couldn't prevent that. And this is what you're left at with a judiciary that's willing to confuse or a majority that's willing to confuse the electorate.
Justice Stewart?
There's a statute that says, you know, it's disappointing to me, who takes a great deal of pride in public service, to have the chief elections officer of our state engage in so much partisan politics. The statute says his job is to, you're supposed to bring on ballot language, he and the ballot board, that is not misleading, fraudulent, deceitful, and not designed to sway voters to vote for or against the amendment. Just tell voters what it is. And as always been my life, voters are educated, informed, intelligent people. Tell them what it is and let them decide whether they should have it. You can always tell when politics is coming into play, because they will then distort it. I've always said, even before I was an elected official, if someone has to stoke fear into you about something, about voting for their position or voting for them, you should beware and not vote for that. And so this is what they do, hoping that the voters don't pay attention and just listen to what's being said. And as I agreed in the dissent, every aspect of the law, the duties of the ballot board and the Secretary of State were violated in that. And it's always suspect, too, when you have ballot language that's even longer than the proposed amendment itself. That's what happened in the Reproductive Freedom Amendment, and that's what happened with this amendment too. But some people view it as a rubber stamp. We're supposed to be a great system of checks and balances with the judiciary and the executive branch and the legislative branch. It's questionable whether we've got those checks and balances there.
Well, thank you all very much. I appreciate it. Let's give a thanks to Justice Donnelly, Justice Stewart, and Judge Forbes for joining us here at the City Club today. Forums like this one are made possible thanks to generous support from individuals like you. You can learn more about how to become a guardian of free speech at cityclub.org. Today's forum was presented in partnership with the Ohio Debate Commission, and our gratitude to IdeaStream Public Media for their production support on this afternoon's forum. A reminder that Election Day is Tuesday, November 5th. Early voting has already begun. It's time to lock in your voting plans if you haven't voted already. You can visit voteohio.gov if you need help finding your polling location, track your absentee ballot, confirm ID requirements, or view your sample ballot. You can do all that there. Up next at the City Club on Friday, October 5th, this coming Friday, we will hear from Pranita Gupta, former Special Assistant to the President for Labor and Workers on the Domestic Policy Council, which is part of the Biden White House. She will be discussing the role of coalitions and partnerships in rebuilding the economy. You can get tickets to this forum and learn more about other forums at cityclub.org. That brings us to the end of this forum. Thank you once again to Justice Donnelly, Justice Stewart, and Judge Forbes, and all members of the City Club for joining us. I'm Karen Kasler. This forum is now adjourned.
For information on upcoming speakers or for podcasts of the City Club, go to cityclub.org.
Production and distribution of City Club forums on IdeaStream Public Media are made possible by PNC and the United Black Fund of Greater Cleveland, Incorporated.